There's little me. Hi, can you hear me? Hello? Huh. I don't know if anybody can hear me, but today is a work day. And this is going to be boring AF, as you can see, the scroll. Boring work of reporting, sitting, writing, rewriting, snacks, cats, lather, rinse, repeat. Yes. Okay. So this is I was talking to a few people and it's earphone day because I'm going to be moving around a lot. So buckle up. Um, I've got some things to do here, and I thought I would bring you along as I go through things. So, uh, this is the boring work of a journalist, a reporter, a person, a human living in the world. And this is what my Thursday is going to shape up to be. So, first of all, we are going to be doing some Delphi things. Let's see. Thursday, July, I start by making a list. Thursday, July, what is it? The 1100th of May? No, July. Okay, so first of all, I put on here simple things. Make bed. Check. I'm already ahead. Take pills. Done. Nailing it. Okay. 3 is, let's see what's on the slab. So today I'm going to be working on a pro se motion to compel a motion to intervene and compel to access public trial exhibits, um, because I know that there is a lot of, um, I mean, obviously people know that there's a lack of transparency to a stunning degree in the Richard Allen trial, um, or the Richard Allen case. It's now concluded. If anybody joined me the other day, I made some phone calls to find out what the hell was going on. And I was talking to a couple of folks who I trust, who are legalish, lawyerly, not lawyerly, but lawyerly, LY. And I was like, screw it, I'm just going to file a pro se motion. And I started doing this because I am just PCA of what? What are you talking about? Probable cause? What? PCA. This is what I'm doing. So just hang on. Just you people hang on. Hmm. Let me add. All right. Let me add this nonsense. This is what I'm working on. All right. So I'm using, well, why don't we do this? So let's start at the Indiana courts, right? So, so I'm going to be filing into a case, pro se, to intervene to get access to not only the trial transcript, but the exhibits that were at public, part of the public trial. And so I'm crafting this pro se motion based on NBC Universal's motion. A lot of this language is reusable. Things have changed since NBC filed theirs, but I'll show you sort of the process that I am going through here. And honestly, anybody can do this. And again, I think that's the thing. It's like people can do, anybody can do this. So if I want to e-file into a case, so this is the Indiana Judicial Branch, and each state has one of these. And every state, I believe, what? PCA? Don't we have the probable cause affidavit? Wasn't that like a long time ago? All right. All right. So what I'm doing today is so I don't know what that is, but I'm requesting all of the we are at a point now that the case is in appeal. So this could be any case. Anybody can file into a case pro se to intervene for public information. Because what has happened with the Richard Allen situation with Indiana and with Judge Gull specifically is that she has made it impossible, along with Jody Williams, to access public information that is bought and paid for by the Indiana taxpayer. That's a problem. Nobody should be paying $1 a page. Nobody should be having to jump through as many hoops. And so, you know, putting something on the record in an official way at this point to me makes the most sense. So I've already signed in. So, all right. Okay. So I am going to file into a case. Okay. Well, I mean, after sweet weird cat, Mr. Fiends, after this tutorial, you should be able to whip one of these things up lickety split. So I'm not going to talk all the way through this because this is literally just me doing my daily. So anyway, so anybody can, all you got to do is create an account. So you can file into an existing case. And we know that this is in Allen County, and I can't remember. Is it Odyssey or Quest? Odyssey, is that family court? I guess we'll find out. Hi. Hello. Hello. Hello, everybody. Hi. As you can see, scrolling across the bottom, it's going to be boring AF. But we're going to try to TCB. No cases. Okay, so I think that I have Quest. Pate. Okay, all cases. Nope. Okay, now why is this not showing up? I mean, I have the case number. Hang on. Damn it. I can't remember. So new case. See, but this is all. Here we go. So I already did this yesterday, so I know it works, but so I'm going to file into the criminal case. Then I'm also going to file into the appeals case. Oh, fantastic. So I'm filing a pro se motion, Michael, because nobody, I'm getting all sorts of encouragement from many learned lawyers from across the spectrum, that yay, go do a pro se filing to intervene and compel public trial exhibits. And there's what docs? I mean, I'm kind of, over all this bullshit. Everybody says that they have a pending. Do I have anything pending? No. I don't know what docs you're talking about. So my motion to compel Michael Osbrook is going to be for everything, soup to nuts. And I'm using the NBC Universal motion to compel access to public trial exhibits, but I'm also going to, I talked to a friend of ours the other day about filing then into the appellate court, just for the hell of it, a motion to compel Jody to file the transcript immediately versus waiting. So that's what I'm doing. I don't know what documents you have, but man, if you've been holding out, now would be the time, because I'm not starting a new case. I did this yesterday, and this is making me mad. File into existing. Is it back in Carol? I think that might be it. Hang on a second. I mean, dude, yeah, I have a bunch of shit sitting in my email that I'm tempted to share, but I don't know. I'm pretty frustrated. If you have things that you've stolen, please share. I mean, Jesus wept. Let's go. You got this nincompoop over here trying to file pro se on some bullshit. Let's see. Okay. And I don't mind doing this because whatever, but this is dumb. Everybody should be able to do this, and everybody can do this. So what are you talking about? Where? Osbrook, I swear to God. In the whatever you call it, in the appellate. Okay, that's just, you know what? This cryptic. Call me. No, nothing I have. Okay, you're being cryptic now. I have no idea what you're talking about. Yes, I do. I find it very curious, and I find it fucking frustrating as hell. I'll read to you an encouraging text message I got the other day from a lawyer. You know, not any of the lawyers that I know. Okay, so here's the thing: share it. So let's do that, right? Why are we not doing that? Somebody needs to explain it to me, because I'm just like, if I'm doing all of this bullshit for no reason, then the fuck? Okay. So I got a very encouraging text the other day from a learned lawyer And I went and I looked up everything is under C. I love your idea for pro se filing. Calling out Jody for being obtuse related to exhibits is the ridiculous requirements would be or should be a part of that, I guess. I'm glad somebody's trying to do something. This is the thing, people. I am so sick of everyone asking, what can we do? What can we do? I don't know, man. What can you do? It doesn't, Michael, here's the thing. They're public, right? There is no earthly reason. There is no earthly reason that if this is filed in the appellate record, that it shouldn't be available to us. I mean, if only maybe there was somebody that could actually do something. Not you, maybe. I mean, I looked in the case yesterday. What is even happening? Oh, I'm so pissed. If there's shit sitting over in the appellate court, so, okay, great. So who do I call? Give me a phone number. Send me a text because this is nonsense. If they're all sitting over there, Michael, then T shouldn't have sent her money, right? Where are they? And as a lawyer, you should be able to access those, correct? Why are they being withheld? Can anybody explain that to me? Okay, but what do you, okay. Osbrook, I'm going to put you in timeout if you don't do something. All right. So, Indiana courts. I'm so pissed. It's all very obtuse, all very obtuse. Where? What are you talking about, Michael? Because, hang on, there's nothing that shows up. So there's nothing that shows up in the docket, Michael. There's nothing that shows up in the docket at all. Right? So here we go. So we have the original action, Court of Appeals, right? Right. So we have all of our doodahs. Notice of completion of clerk's record. Appearance, right? Okay. Motion, right? Okay. Document transmitted. And notice of completion of transcript. And until filed by the lawyer. Why would that be? Well, that's some bullshit. No, there's no, what are you talking about? The thing, here's the thing. I think maybe you might be misunderstanding me, right? There's a notice of completion of transcript. Yes, we all know that, right? So now what? Notice of filing. What are you talking about? Yes, there's a notice. No. So why? Okay. All right. I think Michael's led me down a rabbit hole, but uh wouldn't be the first time. No, I mean it's the same as it ever was, right? Here we go. Notice of completion of transcript. So why did Michael Osbrook? No shit. No shit, friend. So here's the thing though about this. Usually show up until filed by a lawyer. Why would that be? Why would it be down to the lawyers? Oh, God damn it. I'm not giving you a link because you're making me crazy. No. Unless you can bring all the things that you say are filed, nay. I can't. Lawyers shouldn't be the ones that are running the docket, right? God damn it, Michael. All right, fine. You know what? Hold me hostage. That's fine. I'm borderline um I'm borderline checking out over here. Get it? CZ as in like you want your neighbor's goat dead. So you ready for some Eastern European realness? I'm gonna give you a link. Mm-hmm. Mm-hmm. Yep, I'll do it. No problem. I don't know how to do it. I can't remember. I'm so mad. Let's see. I'm gonna give you a link. Just yeah, I don't care. Look, man, I do this shit all fucking day. And I love Michael Osbrook. I just can't find how do I give him a link? I can't remember. Uh, referral link? No. Well, and the thing is, hey girl, hey. How's the Great White North? Um, so my intent with this stream was to just bore everyone with going through how I go about my business during a day. Um, yeah, you're right up there. You're right up there. Yes. I'm trying to figure out how to share a link. Okay. I'm going to regret this, aren't I? All right, Michael. Mhm, mhm, mhm. Where are you going? Where are you going, Royal We? All right.
So if you do this in Czech and I do this in Polish, we'll understand each other perfectly.
I know, I know. Can everybody hear Michael? Hang on a second. Can you hear Michael or no? Am I gonna have to take off my goddamn headphones? Can,
I don't know. You can hear me. You can hear me, right?
yeah, I can, but I have my earphones on, so I'm not sure if I have to, how this works. You can hear Michael? Yes? All right. So, co to je, pane profesorka, co to je? Co to je? Nerozumím filing. What are you talking about?
So there's a notice. The notice of completion of
Yes.
the record is different from the notice of filing. The notice of completion is
Yes, I
something,
know.
but and so I haven't been following the appellate filings. I thought that the notice of filing of the transcript had been filed, but if it hasn't, then it hasn't, and that's the date that the briefing schedule runs off of.
Right. So they have, I mean, this is, yes, correct. Yeah,
So again, if you're looking at the appellate docket
I
and
am.
actually, well, if you look at the trial docket, go all the way to the end and see if the Carroll County clerk has filed.
Right. So let's do that next because I went there yesterday and I do the thing, and this is an interesting point that you make because in going through my pro se motion to compel, which nobody should have to do because there's nothing but media attorneys and stuff in Indiana who should be all over it, but who cares, right? That I do know, I saw here, okay, so let's look at this first though. So when we look at the orders, right? So notice of transcript, right? Completion, but you notice that, so now just, and I understand this, Michael, so just hear me out. That if you see when, that service, so service goes to the trial clerk of Carroll County, obviously, because that's where this ultimately needs to live. And so, uh, hang on a second. And so let me go back to then the, let's see, case number. Damn it. Mm-hmm. 08C01. It's interesting. I was going through some of the pro se filings before, including Andrea Burkhart's. It's interesting that nobody has taken the course of, hey, I don't need to be a journalist to access this information, which I think is I don't think that approaching it as a journalist is the right way to go. I think approaching it as a member of the public is the correct way to go, but that's just me. Hang on, let me see if I can't remove this, add this. I got to add a different page.
Let me point out that Angela Burkhart, much as I love Angela Burkhart,
Andrea Burkhart.
her request, Andrea Burkhart, her original action attempt had an absolutely fatal flaw in it.
Okay, we're not going to talk about that right now because
And
I'm getting derailed. So I'm going to need you to hang on just a second. Okay. I'm trying to get to here. Okay. So this is the, here it
is
is.
there in
So
the
this,
Court of Appeal or in the trial court a notice of filing of the transcript?
so in the appeals court, right?
Yeah.
Hang on a second. So in the last entry is the notice of completion of transcript. right? Okay, so it says that's on the 7th of July. Certificate of service, method not provided / not specified. So there is no notice to the Carroll County clerk. The last time in the appellate court thingy dingy docket on June 6th, the last thing to be served, to have service to the clerk of Carroll County, was the granting reporter's motion for extension. So looking at the docket right now, the very last thing is just a notice of completion. So that's where the appellate case is at. So if we go back then to the criminal case, Carol, the original. Okay, well, it does say 7-2, notice of completion of transcript filed. So do you see that on the screen?
Yeah, I can't read that on the screen. I'm on my phone and I'm looking
All
at
right.
you know,
Yep.
this is stuff that you know Kara would know head off the top of her head.
But here's what I'm telling you right now, okay? So I'll read it to you because I looked at the appellate, right? And so now I'm looking at the closure of the criminal case, or the transcript order issued, Stacy Juliana, blah, blah, blah. Order issued, request. So, okay, so let's go back to where you and I started talking about kind of the chronic thing and whatever. And Stacy Juliana filed for the transcript, and that was done on 6/4. So that was a supplemental request for transcript, and refers to the court reporter. 6/5, automatic e-notice was issued to all the parties. And then on 7/2, in the criminal case, right? Not appellate docket, the criminal docket, 7/2/2025, notice of completion of transcript filed. So that is the and I don't remember seeing that before. Does anybody remember seeing this?
What is it that
That there is a note in the Carroll County, right? In Carroll County.
right?
One moment. That there has been a notice of completion transcript filed. So it shows up in the original case, in the trial court. So it shows up. But what does that mean? I need to call Weineke. I
Well,
need Weineke up here.
so one thing that causes me some concern
Oh shit. Okay, go ahead.
about any ability to get a copy of this is Rule 12C of the appellate rules.
Mm-hmm.
Rule 12 is about transmittal, and C is about access to record on appeal.
Uh-huh.
And it says, unless limited by the trial court, any party may copy any document from the clerk's record and any portion of the transcript. But that's any
Right.
party. After a transcript or appendix has been transmitted to or filed with the clerk, a party to the appeal may arrange to have access to the transcript or appendix during the time period the party is working on a brief, subject to any internal rules the clerk may adopt, provide an accounting for the location of those materials and for ensuring fair access to the transcript and appendices by all parties. Now, this was obviously written in the days of paper record.
Oh, which is a whole other kettle of fish. But yeah, I mean,
But
but
things
hang
that
on, Michael. I'm gonna
so
hang on. Let me just step in here for a moment because I think that so that's the appellate, right? So that's the appellate court rule, 12, whatever. Yes or no?
12C. Yes,
Yeah.
that's 12C, and I don't know. So I'm not an expert, and I don't know how that intersects with APRA. My guess is that
But here, let me stop you. Okay, so let's stop right there because I need to break this down. Um, I need to break this down. So that is the appellate record, correct?
yes,
Okay, I'm talking about the original trial and that needs to be filed with it needs to be noticed or served or transmitted to Sharon, right? Or whatever her name is at Carroll County. Yes or no?
I'm
And I'm
sorry. What's
asking
the
this,
question?
we have two different owners of public information. We have the appellate court docket, we have the appellate, right? And then we have the Carroll County Clerk of Court.
Yes.
Okay. I don't care about the appellate docket for the moment. I want to talk about what has been noticed to Carroll County because that is separate and apart, I think, from the rules of the appellate proceedings, meaning, and just hear me out, meaning that theoretically, and I think actually, hang on, let me look at the last, that Carroll County, that once it goes back to Carroll County, we should be able to access it through requesting it from Carroll County, yeah?
Well, and that's what I'm saying. I don't. So, it's a public record. It's probably a public record under APRA, right? The Access to Public Records
Yeah,
Act. So that's a
sure.
statute. That's a
Yep,
statute.
yep.
Now, what I'm saying is that there seems to be a conflict or a possible conflict with Appellate Rule 12C, which provides for access to the record on appeal. So the record on appeal includes transcript and the docs filed in the case and the exhibit.
All right, hang on a second. I got Weineke. Let me see. Ugh. And, Hey, girl. So I have a
So,
question. Hang on a second. Hang on a second. Hey, Michael, I'm gonna put you on hold for a second, okay? Hey, Michael, okay, there you go. So I'm doing a live right now, I don't know if I know that you're always riveted with my content, but my question is, and you're not on, so, um, but I'm doing this is how the sausage gets made stream, like this is how boring a journalist life is. But what I'm doing is and Michael and I were talking about the appellate docket. Actually, can I put you on speaker so the people can hear? Or no? Okay, all right, hang on.
My docket, I assume.
Of course, yes. Okay.
I want to pull it up so I make sure I'm looking at the same thing you are.
Michael, can you hear Kara? I had to put Michael on mute.
it's a little to cut to the chase a little bit, Kara. I'm wondering how Appellate Rule 12C,
I
which
don't think she
provides
can
for
hear you. Hang on just 1 second, y'all. One moment.
Michael?
Yeah.
Okay, go ahead. Kara's on.
Hey there. So to cut to the chase, I'm wondering about how Appellate Rule 12C, which provides for access to the record on appeal to the parties, might intersect, conflict with, or harmonize with whatever's in APRA about all of this being public record.
I mean,
I'm
it's high of the ages with this, right? Okay, go ahead. Sorry.
Well, okay, so you're looking at 12, you said,
12C.
here's part of the problem with the appellate rules. There's a lot of holdover from when we were paper based. And I think that is part of it. I do know there's an effort to update these, especially around the record on appeal. But so 12C talks about giving any party can copy a document from the clerk's record in any portion of the transcript. And I think part of that was because for a while, and we still encounter this sometimes, the trial court clerk will mistakenly think that we can't have a copy, or like we either have to check it out or go review it in person. Or it can also be, we'll get this from time to time, they will tell me I can't have the pre-sentence investigation report, even though, I'm allowed confidential stuff as the attorney.
Right.
So, yeah, so that's sort of where I think that came from.
So can I just ask one question here to clarify? Because we have an appellate docket and then we have the criminal docket, right? So we have the original trial court docket.
Right.
Okay. I'm looking at the trial court docket right now, and I don't know if we're all saying the same thing or not, but that's why we put up the Kara bat signal, is that I'm looking at the trial court docket, and I don't know if you're there or not, but it says notice of completion of transcript filed in the trial court docket. So that would be, wouldn't it, with Carroll County as well?
Well, so funny enough, the trial court docket says notice of completion of transcript.
Filed.
And if you click on it, it's actually Jody's notice of filing of transcript.
See, I can't click on it so the public can't click on it.
Which is weird.
It's totally weird.
You can't be able to.
You can't click on, and remember, you and I talked about this. You used to be able to click on everything.
Yeah.
No.
That's
yeah.
So they have a way to do that. I just don't know why they've done it that way. We can conspiracy theory put on our tinfoil hats on that one.
Sure. Yeah. I just like to say power of the state. That's it. That's my conspiracy. But so
fair enough.
So you click on that.
Yeah, if you click on it, it's actually Jody's notice. And the notice is really, again, it's kind of a holdover of when we had paper.
Sure.
But the notice of filing is telling the trial court clerk, hey, I'm the court reporter. I'm done. Here you go. Here's my transcript and exhibits for you. And then the clerk is supposed to be the one that holds those.
Sorry. I'm going to be asking questions throughout this, if that's okay. So, holding, when you say holding, that means, holding in the sense of holding for we the people.
Holding for the we people, holding for the parties. So they would actually, if we were back in paper days, the clerk would literally, if I wanted to go look at the transcript as an attorney in the case, I would drive to that trial court clerk's office and say, hi, I'm here. Can you let me look at it?
Mm-hmm.
and she would hand it over the desk. So literally holding it. Now, in practice, most of the time, the court reporter is holding it still, in part because the exhibits are a little bit different. Like
Hang
if I
on,
have
my
yeah.
goddamn. Okay.
Like if I have a handgun, if I'm the prosecutor, I put a handgun into evidence. They're not going to put the handgun itself into the exhibit volume. So who holds on to that actual handgun? That would be the court reporter. She has a vault that she locks it in the vault. Kind of like a bank. True story.
Are you
True
kidding
story.
me?
No,
No.
Holy
What's
shit.
that, Michael?
What?
Oh.
No, you're absolutely right. No, the court
That's
report is
crazy.
actually court report is hanging on to all that stuff. In these incredibly old cases, you've got, and there are some cases where the court reporters, have the exhibits 20 years later.
Yeah.
Is it a microfiche?
Is it on what?
Microfiche?
Well, the court of
Is it a mimeograph?
the court of no, they have the physical they often have the physical exhibits 20 years later.
Okay. So back to
and that's actually a good thing, because if you go back, like on a fingerprint case I had, I went to the court reporter and she had the actual latent print card that she kept in her vault. And that was actually a good thing, because I could look at the actual real evidence.
right.
And so they have so really it's the court reporter who's responsible for making sure that everything is kept in the form it was given into evidence.
So the court reporter.
Yeah, and if they're allowed to send some stuff down to Indianapolis to the Court of Appeals, to the appellate clerk's office, but other stuff they're told they need to keep.
Okay.
And that's understandable.
Sure. Yeah. You don't want a lot of, you don't want a lot of stuff moving. I get it. I think that there's a certain sense of like, it gives me the heebie-jeebies a little bit to know that people in Carroll County are the holders of this. So of actual physical evidence. I mean,
well, and actually, so it could be right now, it is so what should happen is that even with those exhibits, I think right now, the ones that are going to be sent to Indianapolis, that should be in the Carroll County trial court clerk's possession. But I think someone reached out to her. I don't know if it was her or someone else. And she said, no, Jody has it.
right.
And that's okay. It's not that big of a deal. Right.
Right. But I think my biggest, so the thing is that when you click on this, when you read that, what do you read that to mean? That so let's go back to the trial court docket, right? The trial court docket, when you click on the, let me see here, the notice of completion of transcript filed. So in the trial court case on 7/2/2025, okay? What do you, can you read to me again, when you click on that, what do you see?
When I click on it, so what happened is somebody, unfortunately, at the clerk's office put it in as a notice of completion of transcript. It is not. It is a notice of filing of transcript. This is why people don't practice appellate law unless they're nerds, is because it sounds exactly the same. This is stupid, right? Why do we have two notices? I don't know why we have two notices, but if it's a holdover, we do. All it does is it says it's the court reporter telling the trial court clerk formally, I'm done. And that triggers the trial court clerk. She now only had 5 days from the date that Jody told her my transcript is done. She only had 5 days to file the notice of completion of transcript, which goes to the appellate clerk and tells the Court of Appeals, everything's done and the transcript is ready to go. And then you kind of switch over to where when she files that notice of completion, which she did on the 7th, 5 days after Jody. So everything's done right. That notice does two things. It tells the appellant your 30 days is running. and it tells the appellate clerk everything's on track on this appeal. Because see, if any of these deadlines are missed, the appellate clerk could trigger to the Court of Appeals, this needs to be dismissed. The appellant's not, prosecuting their appeal or not doing their appeal properly. Everything's on the appellant to make sure all these deadlines are met.
Right.
And so, yeah. So everything's met. So, but what it does not do yet is it doesn't transfer the actual transcript and exhibits to the appellate clerk yet, because Appellate Rule 12 tells everybody, okay, everything stays at the trial court clerk. Again, this is a holdover because it used to be appellate attorneys lived in the county, worked in the county where the appeal was.
So hang on one second.
Anymore.
So let me make sure that I ground this in. When I refer to trial court, I'm going to say Carroll County, and when I refer to appellate, for better or worse, I'm just going to say Allen County. Okay.
Okay.
Does that make sense? Or should I say
you're saying Allen County for the court reporter or for the appeal?
Well, for the whatever the docket is, I'm going with Allen County because it's Jody, right?
Yes.
Okay.
Jody.
So right now, everything lives with Carroll County right now, including the transcripts.
Yes.
Okay. So
well, except Jody may have the exhibit.
Well, whatever. Okay. So yeah, I'm talking. So I think that, yes. So I think you're right, because that's how everybody's been submitting and trying to get all this information and, getting rejected and all this other nonsense. And so Kara, to go back to the beginning of all this, it's when I started talking about doing this pro se filing for public access. And I'm like, why am I having to do this? Right? Why am I having to do this kind of bullshit and enter? I mean, I'll do it. I'm not happy to do it. But then again, I'm not happy to do anything. But if it exists in the world in a form that's accessible by any Indiana lawyer, shouldn't that be something that some Indiana lawyer should be able to access?
Yes, except that it's not currently the transcript and exhibits. Indiana lawyers, unless they're the parties, can't actually click on it yet because it's not been filed into anything. It will be filed into the appellate docket when it is transmitted downtown to Indianapolis. Now, yes, Richard Allen's appellate attorneys or the Attorney General's office, I assume, could file a motion with the Court of Appeals and ask the chief judge to make the trial court clerk send it downtown.
Now,
early.
Could say a journalist or angry public citizen send a motion to compel to transfer early?
To the appellate clerk? I mean, theoretically, no, there's no authority in the appellate rules, but, it doesn't mean that you can't ask. That's the nice thing about our appellate clerk and our appellate courts. You can ask the appellate court judge to do anything you want. And they generally have the authority. There's a rule that says that they can actually act outside of the authority of their own appellate rules, if they feel that it's necessary. And so that's why the judge could grant that.
Meaning, because I think the thing is that I'm galactically cheesed off. I mean, I'm royally ticked. Now I'm galactically cheesed off. So it's ticking up a notch, because the amount of money that was quoted to Teresa from Criminality, if that transcript exists, we should be talking, she shouldn't have to pay for it because it's completed, or she should only have to pay a reasonable amount, not $1 per page, right?
And here's why, because technically the court reporter has already been paid for its preparation by the taxpayers of Carroll County, I assume.
Right.
And therefore, they paid $4 a page or whatever the number is for public defender transcripts under their local rules.
Okay.
Now that it's prepared, you're not asking for it to be prepared. You're asking for a copy.
Right.
And so that, I think, falls under APRA there used to be a fee schedule that the Supreme Court would put out for what you paid for a copy, but I don't know. I think it's just now under the APRA statute. Because I tried to look for that and could not find that again. So either way, it's going to be at a discounted rate.
Yeah,
It would be like, 10 cents
A
something
page.
like that.
Right,
a page.
right. And that's
Or
typically what
whether-
it is.
What's that, Michael?
I said the $1 page thing, I mean, whether it's local or still in the appellate rules or someplace, is also a whole over from paper days, and not unreasonable. Like if somebody has to stand there and physically copy 18 volumes.
Okay.
Um,
Sleuthie has brought up an interesting,
bucket
and this is something that I was trying to get to because I'm trying to understand what feels like a double dip on Jody's part is to me. Sleuthie is saying that since it's a copy, it's at $1 per page. Previously, it was $5.75 a page.
$5.75 is what the court reporter gets paid to actually produce the transcript. $1 a page is to copy it.
Right.
Right.
But here's the thing.
And it's not a
Copying
double dip by it's not a double dip by Jody. The $4,500 or 46, whatever it is, will go to Carroll County, not to Jody.
But okay, so but that is double payment, right?
Well, the 4,500, if I understand right, that is not the that was not the prep. That's the copy. Is that right?
Yeah.
That's for a
Yeah.
$1 page copy.
But why can't I don't? But again, I don't understand this, and I'm not trying to be combative here, but yes, I am a little bit. Is that I told both of you at one point that I just got all this crap for free from an Iowa county for just calling. And so I'm having a hard time understanding with everything because this is part of the access problem, right? I mean, we don't have access to the courtroom. We don't have access to the trial exhibits. We don't have access. Are they going to charge every single person this amount of money? Or what? So I don't know. I'm struggling with how to push back against this idea that that's something that folks should have to pay.
Here's my advice. So if we have a definite something from someone who reached out to Jody and Jody said it's going to be $4,500 just for the copy, right?
Mm-hmm. We do.
One, if it were me and I was just a non-lawyer wanting to do something, you could file a motion into the Court of Appeals saying, look, I understand that, the transcript isn't due to be transmitted until the initial brief is filed. However, the court reporter is indicating that a copy, just a copy, will be $4,500.
Yes.
Excluding exhibits, because that's not going to exclude any exhibits.
Mm-hmm.
This is, you could say that this is going to take a lot of time. That's a lot of money, whatever.
Yeah.
And, public interest, if merely this court ordered her to transmit the transcript or the clerk to transmit it early, we would be able to get access to it.
That's what I'm going to do then, because the thing is because I'm not I'm not going to even mess around with the trial court.
Yeah, here's the nice thing. Our chief judge for the Court of Appeals is from Marion County. He was a judge a long time in Marion County. They have a very open transparency policy in Marion County. And he worked under that. He understands that. He embraced it. Mm-hmm. And so I think that you're going to get, I'm not saying he will grant it, but I'm saying that you're going to have a very fair consideration of it from him as the chief judge, because, we encountered this when we got to the Supreme Court and did the original actions. We were concerned about, hey, can we share this stuff that we filed? Is that okay? Do we need to, is there a problem with this? And everybody we talked to was like, no, you can give copies of this to media, to whoever you want. as soon as it's up on a docket and it's public, it's available for public consumption.
Right.
So
Right.
that's the thing. You just have to get it to the docket, and
Right.
then it will be readily available. Where I think you and I talked, Andy, where I think the concern is going to be is when this thing finally makes it to the appellate clerk's office, the exhibits that are not documentary, so they're not scanned, those are going to be where the public may have a harder time getting them, because I don't know if the appellate clerk, how they're going to be able to deal with all of the requests for those.
Yeah.
I assume what they might do is make a dummy copy or an extra copy for the public to be able to check out or get copies of, and then they will keep the original for the parties and the court to be able to use. But I don't know.
But I
because
think
I'm
you're
not sure how they handle that.
See, I think that you're making a really, because I was noodling this over last night, and I'm like, and I think I talked to you about this too, Kara. I'm like, should I file in both the trial and the appellate court? And I'm like, why am I even bothering with why am I wasting all my time here with what's going to get rejected? Right? We know that that's going to get rejected because the judge's goal, right? So, but I do think that
No. It's not no. So here's what I do, and Kara's free to disagree and listen to Kara, not me, if she disagrees.
always, right?
I would ask the trial clerk first to transmit it.
I think Sleuthie did that.
And when they to transmit it to the Court of Appeals.
Ah, ha, ha, ha.
She will, I can already tell you.
And when they say
no.
Okay.
She will say no, and here's why. They say no to us about that all the time. They say we are not allowed to transmit it under the appellate rules until it is formally requested by the appellate clerk. And technically they're not wrong, because appellate rule 12 tells them that they shall hold, if I understand right, they have to hold on, but they shall retain the transcript until the clerk notifies them to send it. So that's why we have to ask for permission from the Court of Appeals to transmit it. Now,
and the no from the trial court, and yes, 12C absolutely says that.
All right, I'll be right back. Keep talking.
I'm only suggesting that a no from the clerk might be useful. Might be useful for the immediately following request to the Court of Appeals.
That's a good idea. And although from what I understand now, I have not talked to the trial court clerk, but I think that what someone said she told them was that she doesn't even have the transcript, that Jody has it.
That's nonsense.
And so
that's crazy.
What's that?
Isn't that nuts? Because doesn't it have to originate? Oh my God.
It's not nuts, because this does happen where the court reporter will hold on to the transcript. And here's the deal. It's pointless because it's all electronic.
I know. This is what I'm saying. But this is back to the point about that money, right? About the and I've been trying, I know. So here's the thing about, and I think that to Michael's point, ticking the box of making the ask is appropriate, right? Tick that box. We've asked, it's not going to happen. That can then go into, a request to the appellate court saying, hey, we've already done this. We've already asked and gone through. And oh, by the way, we went through, Jody Williams, who now is suggesting that we're going to have to pay $5,500 or whatever it is. That's made out to her personally, by the way, which is weird, but okay. And that's prohibitively expensive. And, Indiana prizes, the Constitution of Indiana, the Indiana Constitution, along with the APRA rules, prize transparency and faith, public faith in our judicial system. So, maybe being able to show we've tried to go to the care, and I'm not saying that I have done this. I'm saying people have been doing this, and we all know that.
Right.
So I'm just like kind of like the royal us. But I'm wondering if at this point, is it worth a call to, like, for me to call the appellate clerk or whoever the hell it is and say, hey, you know, and ask them about the ability to do this, or should I file into the appellate court first or call? Is there any benefit to calling?
To calling the appellate clerk?
Well, whoever I got to get this stuff going.
Well,
The
the
appellate
court
clerk,
of
probably-
appeals doesn't have it yet.
right, appellate clerk does not have it yet. And
Oh,
if you
right.
say to them, "Oh, can you tell the trial court clerk to transmit it?" They will say, "No, we have to get an order from the Court of Appeals to be
Okay.
allowed to do that."
Okay.
Um,
All right. So that makes
If
sense.
The other thing you can do is simply send an email to Stacy Uliana and or Mark Lehman and say, could we have the transcript, please?
Okay. I'll do that too.
you can do that. Yes, you can do that. You could send it to the AG's office
AG,
too. The DAG's on the case. Yeah.
You're right.
Well, except the AG's office. So the AG's office may not have it yet. They've only been served with the notice of filing, and they're not, so they may not have gotten it yet. I mean, they may have access to it for sure. I don't know, but it's not clear to me. I mean, we're into Stacy and Mark's briefing time, so they certainly have it.
They do, and here's my position on that. In normal cases, no, the AG's not going to ask for it early. But in this case, I wouldn't be surprised if they didn't ask for a copy early because they know how big it's going to be.
Yeah, no, I'm not saying they don't. I'm just saying it's not certain they do.
Now, Kara, when you go into the appellate docket, is there anything, when you click on the last thing that was down there, all right, let's see. The notice of
The notice
completion.
of completion?
Yeah. Yeah. Is there anything that comes up on that?
Yeah, it comes up with the Carroll County Clerk's notice of completion of transcript. Yep, it's the right notice that she's to file.
Okay.
Yeah.
And so when I file into, because I'm using NBC the NBC sort of template here, and it's, you know, it's actually pretty clear stuff to this motion to intervene and compel. Does it still have to be a motion to intervene when I file into the appellate court?
I don't know that you have to intervene because you're not real. Like, usually we think of an intervener as somebody who's, you know, like inserting themselves to become a party, I guess.
Well,
to
for
the
a limited
proceeding.
purpose, though, right? For a limited purpose of
Yeah.
obtaining public documents.
The difference is that there are actually trial rules about intervening, but there's nothing appellate rules about intervening.
Yeah.
Okay, so I can just do a motion for like a request. I mean, I'm not sure how to term it.
Yeah, I'm not either.
So I would,
Let me see if I have one.
you know,
I
what
can
about
send you.
motion to compel access? Well, no, because what I'm asking is, well, this is to compel public access, though. I mean, let's think this through. We're asking the appellate court to intervene on our behalf as you know, we the people, to get access to what the public has already purchased, and that there have.
I'm going to interrupt you. Here's how maybe you do it.
Yep.
And this is another reason to get a no from the trial clerk first. You move to intervene the way NBC did.
Yep.
In the trial court and ask for it. And once that's denied, then you kind of have standing to go to the Court of Appeals.
Yeah. See, I was trying to avoid that. Because how long is it going to take to get denied, right?
Oh, my guess is overnight.
Oh, well, hell. Okay.
No, I don't, I almost wonder if, she might delay that for a bit.
Well, that's just, and the thing is that,
Why not?
yeah, I just don't have any faith in this. And I think that's why throwing,
The email to Stacy and Mark, could say, look, there are all these complicated things we can do and be delayed. This is a public record. Would you please, make it public?
yeah, that's not going to happen.
Well,
I'm
good.
happy
Well,
to do it.
that's part of the story too, isn't it?
I know it totally is. Believe me.
I just I emailed you, one I filed in a case, ironically from Allen County. But I sent that to you so you can try to use that. That's something that I filed into the appeal, so you can kind of change it to fit what you want. If it were me, I would call the trial court clerk
Yep.
and formally ask for it. If you want to record the call, you can. It's one party state in Indiana. We don't have to get permission from somebody else.
New York is New York's one party.
There you go. So you can record it if you're concerned that the Court of Appeals, if you put it in your motion that she said no, if you're concerned that they won't believe you,
Yeah.
you could put a link to the recording.
Yep.
Or you could just say in there,
Well, and
I called, here's what was said.
Well, and so that's kind of what I started doing because I had started doing this motion to intervene. And so I had started building my case. Like I contacted Jody, here's what I was told. Because I did record it because I don't trust them and because I need to make a record. And so, I pulled a paragraph from what I was being told by Allen County. And it was basically that, why we couldn't get access to X, Y, and Z exhibits. So, but that was also the transcript issue. And so that's, when I found out Jody's on vacation till the 1100th of June, 2032. So it's like, all right. But so I have that documented. So I've already done that, but I can go back to Carroll County and make the official ask. But again,
because here's the thing. And it's not your fault that we keep conflating Carroll County and Allen County, because I think that conflation occurred during the trial when we had like the Allen County court administrator doing stuff.
Yeah, you're right.
Yeah. But technically it's Carroll County. And if you were like going to sue or something or file a complaint or whatever under APRA, you'd be filing against the Carroll County clerk because this is Carroll County's case. And so they are the ones that technically should have the transcript and exhibits and are responsible for public access to them.
Well, and
right now,
it's interesting because way back in the day, I think it was maybe December of 2024 when Nick McClellan told somebody if they were willing to come down there, they could look at whatever. And that's actually the way it should work. You shouldn't have to go down there, but I'm just saying that is something that, it's just, so that's what I'm going to do then. What I'm going to do is I'm going to reach back out. It's been a while since I've called Carroll County. And I think Sleuthy's probably done all of this too, but I'm going to try to put together why am I doing this again? Anybody?
Oh, you want to read the transcript?
That is, I guess it's, what it is though. I'm frankly just really, really sick of the way that the government is just holding public information hostage. And it shouldn't be down to, and this is a thing that I keep trying to reiterate to folks, is that you don't have to be a journalist to do this. You just don't. We don't have special status. And I don't know if that appeals or plays for or against filing pro se to get access to public information. Like I'm inclined to not even include that. Why? Who cares? It shouldn't matter. In my opinion, it shouldn't matter. I can do that, but it shouldn't matter because it's public.
Right.
I mean,
And
seriously,
we should all have access to, and you know how it happens in real life, like, you know, Fox 59 or something here in Indiana wants a copy of a probable cause affidavit or something. They don't jump through all these hoops.
no.
They either call a lawyer they know, or they have somebody at the trial court clerk send them a copy. I mean, this is just routinely done.
Yeah.
So it's just that this case has been different from the jump.
Right.
So
Well, and okay. So one last thing though is that, you know, Sleuthy is saying, I really hope we get them on 7/21 when Jody gets back. But again, my thing is that I just have it makes me a bit sick to my stomach that there was that huge charge and that she should get, you know, she crowdfunded for that. And to me, that's inappropriate. I feel
to have to crowdfund.
well, but it's also inappropriate to charge that much for an electronically sent document that's already been created.
And I know the frustration is going to be that they may get the transcript, but they're not going to get. I mean, there are just some exhibits that, for reasons I don't understand,
Yeah.
are being denied.
Yeah.
And that's just not how we do things in Indiana. Those public access rules are, I mean, the presumption is usually access. So I don't understand why there are a lot of exhibits being denied.
Yeah. Yeah. I mean, I was told
But-
the other day that I couldn't get them because they were filed in a manila envelope. I'm like, excuse me? They're trial exhibits. I don't care if they were handed over in manila. And this is casings. This isn't, you know, when I was talking to Dawn or whoever at Allen County, she was saying, you know, oh, were they crime scene photos? I'm like, no. I want nerdy stuff. I want the you know, I want the printouts of whatever. It was just so like, not everybody wants gross shit.
Well, you know, in Dawn's defense, she probably didn't know because
No, I know.
you know, she may
No,
not
I
have been in
know.
the trial. She's, you know, she doesn't need to know necessarily the why something was confidential or not. It's just that,
I
you know, I understand. We've all had the runaround for, you know, since 2022. So
who else has
we're all kind of used to it.
okay. Well, I just on principle, I think it's disgusting that they're charging that amount. I just honestly, I think that's ludicrous.
I'm trying to figure out where the dollar a page comes from, because there is nothing about that in the Carroll County local rules, which I'm looking at right now. And for transcripts, it says requesting transcripts shall make a deposit with the clerk of Carroll County sufficient to cover the cost of the transcript at the time of the request, unless other arrangements are made with the court who is preparing the transcript. There is nothing about $1 a page in the local rules, and as noted, I think the $1 a page thing has been taken out of the appellate rules.
Yeah, I think it has, and partly because the APRA statute, if I understand right, is either actual copy cost or 10 cents a page or something. And so the thing is, I think they had to take that out, in part because I would assume that the statute trumps any kind of a court rule on the cost of public access.
Right. Well, and this is what Sleuthy's saying.
I could not find $1 a page anywhere.
I think that they're probably going on old information and just an ongoing desire to be as opaque and control freaky as they can possibly be. So Sleuthy is saying, here's the deal. If someone doesn't want to use hers for whatever reason, and they decide to request their own. Oh, never mind. Sorry. Let's see. Clerk is required by Indiana law to collect copy fees. Right. But that's copy. That's hard copy fees, right? Plus, she's citing.
Well, Yeah, what she's citing as because yeah, they may be required to charge a fee for their actual cost of making the copy. And again, it's kind of weird because the official transcript itself is not paper.
That's
It
what I'm
is
see,
electronic.
so this is the disconnect here too. So I think that Jody is telling T, from what I can understand, is that Jody is making this $1 thing that she can get, that she will send her a stack of papers and a PDF, right? So to me, it almost feels like, well, there should be, it just seems like manipulating the rule to me, because what Teresa has asked for and what everybody should ask for and what only everybody ever does, nobody sends reams of paper anymore. I'm sorry, this is bullshit. But she's saying, you know, from what I can gather, oh God. Michael. Okay.
If I were to ask for a copy from the Court of Appeals, for example, of a record, which I do with some frequency, they will send me a brief, or they'll send me a CD, and it's everything electronic from microfilm.
Yeah.
Or microfilm, one of the two. And if you were to request a copy to put into evidence, for example, in a post-conviction hearing or something, hey, I need the trial transcript. What the court will take from you, it will not be paper. They want the electronic, because the electronic is now the official copy.
Uh-huh.
So technically, in 91 other counties, if you were to request a copy of the transcript from the trial court clerk, they're going to give it to you electronically if that's what you want. If you want them to print it out, they're either going to tell you no, or they're going to tell you, well, I got to charge you more to print it out. They're not going to want to do that.
But okay, but if we talk about Carroll County, right? We're talking about going through Carroll County.
Yeah.
And that is the difference here, is that criminality went through Jody, probably because I'm assuming, and I'm sure Sleuthy's tearing her hair out in the chat, but that's all right. That she went through, somebody tried to contact Carroll County and they referred her to Jody. When in fact, what I'm hearing is, no, that's not how that works. And it should be on Carroll County.
It should be now, as of July 2nd, because that's whenever the court reporter told the clerk, I'm done, here you go. Because technically, what should have happened is that when the notice gets filed, then everything gets transferred to the trial court clerk.
Right. And so when we say transferred, we're talking about something that lives in the ether anyway. So it's not like the Pony Express comes and picks it up, but it is Indiana, so maybe.
You know what, though? What's funny, just as an aside, is sometimes it is the Pony Express style, because the trial court clerk will tell me that the court reporter gave her the transcript and it's on a CD instead of just email.
I just can't believe there's no uniform rules here. It's
there. I mean, here's the thing. In practice, though, it generally works very seamlessly.
Yeah.
So, it's just when people want to be difficult, they can be.
Yeah. I know.
So,
all right. Well, I think what I'm going to do then is try to call down to Carroll County and just ask them, like, hey, you filed, I'm requesting this copy. And then I'll get denied. And then I guess I'll just go take my cat out for a walk. And yeah.
Well, and let them know.
I can't find anything about it. So $1 a page used to be the thing that was charged. Physically copying something. And
Yeah.
I can't find anything in the appellate rules about $1 a page, and there's certainly nothing in the Carroll County local rules. I don't know where Jody's coming up with the.
I don't know. Sleuthy's throwing all sorts of stuff in the, she says that it's, code 333751. I don't know. I'm not sure.
Well, but
Well,
I
that's
thought,
a,
let's look at that. You said 3335.
Title 33 courts and court. Yeah. Indiana code section 33-37-51.
There we go. Document fee for preparing a transcript or copy of any record.
Yes, Belly May.
Although it has an exception by a governmental entity using an electronic device.
Oh, for
I assume that means that means that they can't charge you the $1 for that. So, yeah.
say again.
It says this section applies to a document fee for preparing a transcript or copy of any record. However, it does not apply if the preparation or copying of a record is by a governmental entity using an electronic device.
There it is. There it is. So they can't charge if they send it on an email.
Yeah.
well, I think C is even more important. Whether it applies to the exception or not, unless there's a schedule can't be more than $1 a page,
Right.
but there is no schedule, so they can't charge anything.
Right.
Interesting.
Yeah. I mean, because the thing is that you're right, because it says unless it's, so read that last part again. Entity to use electron.
Legislative body of the county may adopt by ordinance a schedule of document fees collected by a clerk under this section. If an ordinance has been adopted, the clerk shall collect document fees according to the schedule. However, the document fee clerk under this subsection may not exceed $1 per page per legal size or letter size page, including a page only partially covered with writing. So if there's no schedule, I don't think they can charge.
And this is the Carroll County rules?
No, this is a statute.
Oh, okay. Yeah. Sorry. Is this the one that Sleuthy cited?
Yes.
Okay. Sorry.
Here's something Michael said earlier that kind of slipped through. I don't think people caught. The fee goes to Carroll County.
Yeah.
It doesn't go to the court reporter. So
but
I'm not sure why you would need to make the money order out to the court reporter, because she's not the one technically making the copy.
Yeah. So yeah. Mm-hmm. Exactly. So yes. So you see what all of this chicanery. If
I were people though who if I were criminality, I'd wait and see what happens with your motion. It's going to be, if it just goes to the chief judge of the court of appeals, he'll decide it fairly quickly.
Well, and the thing is, she's already sent Jody a money order directly to her name.
I thought they had been kicked back. It has not been kicked back.
No, that was all eyes.
Okay, gotcha.
Yeah. So she said the cashier's check, she was told to be made out to, quote, Jody Williams. That doesn't feel right to me.
Well, if it was before it had been filed with the trial clerk, then it could make sense because technically you paid Jody, the court reporter.
No, this was just last week. It was right after.
No, I don't understand. No.
That doesn't smell right to me.
No.
The thing is, when a court reporter is hired privately to do an appeal, a transcript, then yes, you pay the court reporter directly. When it is an indigent transcript, as Mr. Allen's is, there's no money exchanging hands. I believe she invoices the county, and the county reimburses her at the PD rate.
Right. So T sent a over $5,000 crowdfunded personal money order to Jody Williams for something that should be by statute available at a reasonable fee, if any, if electronically transmitted by a government body.
Well, if at all, and I don't know. So
The overall
I
statement
still
I just made, though.
I still don't know how 12C sort of, and I don't know enough about APRA. So, you know, does APRA make this a public record before it's been filed Court of Appeals? I don't know.
But it's been filed, but it's already done deal in Carroll County, right?
Yeah.
Yeah.
I think it's a public record now. Yeah.
Huh. I'm going to have to ask All Eyes, or maybe somebody in the chat knows, if when people have been sending out for now this is the thumb drives for the exhibits, has that been made out to the county, or does anybody know who those have been made out to? Me?
I'm pretty sure that was made out to Jody. And again, I don't necessarily see a problem with that, because that would have been before.
Right.
It was, yeah.
Right.
And also, I suppose Jody could argue, look, these thumb drives cost me some money, and then me transferring the files.
Sure.
You know, a $25 flat fee.
Right.
To me, it wasn't worth, yeah.
Yeah.
Now, you know, well.
Listen, here's my solution.
I've never had that happen before.
It
is what it is.
Here's my solution, Jody. You know what you did with those thumb drives? Do that with a transcript for $25. Right? Problem solved.
Yeah, and probably no one would complain about that, because it should all fit on a one thumb drive, and would take you. Everybody knows how to. It's a PDF.
Oh my God! It's just send it in a Dropbox or something, for crying out loud. It's just idiotic that this is a thing that we're having to do. I've just never. The federal. I mean, honestly, the feds are not this. I mean, of course, I haven't dealt with the feds in quite a while, but they aren't even this rough. I mean, this is
no, and I can. This is not normal, and we occasionally will have issues where clerks will think that they can't give us something, or will say that their technology, they can't email it, it's too big, so they have to send it on a CD or something.
Sure,
but no, we do not have this. We don't have these issues in other cases. But no one's going to be shocked by that. Everything about this case has been handled completely differently than anything I've ever seen.
So this is, I mean, the Carroll County is going to tell me they don't have the power to do that. I'm going to say, yes, you do, under X, Y, and Z. You can email it to me, because it's been filed and it's a public record. And, you know, she's going to tell me no. And then, so that'll be ticked off. And then I guess I just go straight to, I have to check my email. This, whatever you sent me, Kara, and I will try to make some sense out of, let's see. I mean, I'll find the right format for this, for the, you know, the motion to get public access. But I think there's I think that sort of the building blocks here, the the constant blockage of all of public information, plus the denials at, the trial and trial court level, plus this asking the public to pay just an exorbitant, like a good used car for your 16-year-old, it's going to cost you $5,500. It's like,
Right.
so I think that, but I think that people who favor, and maybe the appellate court will feel this way, people who favor, civil service and the right to public trials, and a little bit stunned by maybe that kind of cost associated with a public document, might offend some more justice or right-minded, not right-minded, but you know what I mean, like public service oriented jurists. I don't know, maybe.
Yeah. I think you're just gonna, I think that the steps that you're taking now are gonna make the most sense. You get the trial court clerk on the record as saying no, and then you can file your motion with the Court of Appeals and see, what answer you get. Like I said, and I'm with Michael. I wouldn't hesitate to reach out to the attorneys too, because they'll certainly Rick's attorneys will have a copy.
Certainly
already. Yeah. And I would be surprised if the AG's office doesn't as well. I would think that they would ask for that early.
Okay. I
So-
see.
Well, the other thing is, McClelland was served with a copy of the notice of filing. You can ask him too. He
got
certainly
it.
has access.
Yeah. Well, but with his private email address, yeah, will do.
Well, maybe send him maybe send the request via the Tweedles.
Okay. Yeah, no, you're right. I mean, sure. Why not? I mean, aren't they a wholly owned subsidiary of the state? But I digress. Okay. Well, I mean, I think that, yeah, I think this makes sense. I mean, it makes as much sense as it's going to make, frankly. So,
Well, I would, you know what? I would send in, so Jody's going to be back on the 21st, right? So in addition to asking the Carroll County clerk, I would ask Jody as well, without payment, pointing out that there is no authority for her requiring $1 a page.
My only thing on that is I wouldn't wait. That's 4 days away. You might have an answer from the Court of Appeals before then.
yeah. Yeah. Because I can file this in today. I mean, I'm looking at what you filed, but I mean, you filed it on behalf of your client, though. I mean, I can just file it as as a member of the public.
Yeah, absolutely.
And then put in my supporting facts, which are, denial, exorbitant fee, not justified by statute, and XOXO, Andy. Really, that's basically it.
Yeah,
And
I think so.
And put some of the quotes from the folks who have rejected, from giving me reasons over the course of however, I mean, whatever. This just shouldn't be an issue. So, all right, let me try to do that then. The appellant's verified motion. So I would just do a verified motion. I can't do a verified motion though, right? I would just do motion to order trial court clerk to transmit transcript to appellate clerk. And I would do it under the right to public access. I'll figure this out, but this is pretty clear. This is pretty clear.
It's real simple and
Is
you
our,
can verify just means you affirm under penalties of perjury what you're saying and it is true to the
okay.
best of your knowledge.
Yeah, I don't-
Yeah.
whatever. I mean, I don't lie. So, I'll just have to look up the appeal from Allen County.
And we
Superior
just
Court.
verify things
Happy-
when we're putting facts into a motion that we can't cite to something in the record to, but we're saying is true.
Yeah, and I
so
would.
that
I mean,
you
I
can verify or not. It doesn't matter.
no, I know, but I mean, the thing is that yeah, I mean, there's, and I can cite, and I will cite to the appropriate statute, etc. But I do think that, you know, in order to put in the quotes from the various clerks and stuff, I would want to verify it,
Yeah. Yeah.
you know, or put a link in or something like that. But
Yep. I agree.
I'll be happy to look at whatever you want to file before you file it, if you'd like.
yep, okay. Or write it, you know, whatever. I mean, okay, great. So, thanks. I think this has helped.
So you think you hate us all the least. I get it.
I know. You're the worst. But okay, so I'm going to kick you off, Michael. Goodbye.
Bye.
And Kara, thank you.
Yeah, no problem. And good luck.
All right.
Keep us posted.
I will let you know.
All right.
Okay, bye-bye.
All right. Bye.
Okay. Hmm. Hmm. All right, let me see. Who? Back to my regularly scheduled program. Let me just send. All right, here we go. Yeah, woman, are you talking about actually I'm gonna put my earphones back on. Are you talking about the public access?
Just using I'm just using NBC Universals because it's much easier. And this is going to be, and I got one, it's going to be much easier than all of that because now that the trial is over and everything has been filed, it's not going to be the same issues. But I am going to file this under public right to access. So whew, tired. You want to see Toots? Somebody said we love Toots. Let's take a Toots break. What do you say? Toots break? She's just chillaxing over here. Mm-hmm. What are you doing, Toot? Ugh. What are you doing, sweetie? Mm-hmm. There she is. There's her grass and her foot. Toot, toot, toot. Oh my God, she's ridiculous. Okay, so what I am going to do is Uh, I am so. I just have a thing for transparency. So does Toots. You do too, right, sweetie? Oh my God. Okay, hang on a second. She's trying to act like she doesn't know I'm here. Oh, okay. All right. She's super cute. So I think she's playing. So I think what I'm going to do is it's hotter than a blowtorch here today, y'all. Woo-wee. I am going to take some time to reconnoiter and go through what I've been sent, all the knowledge, all the sweet, sweet knowledge I've gathered here. And then I will let everybody know when I get to the point where I'm going to file this, I think. And since I believe this is true, but since it's a criminal case, let me see. Since it's a criminal case, I should be able to file into it for nothing. Yes. Can I help you? That's good. That sounds like it'll be good. Listen, I just want the documents. I think that, of course they will. I mean, we know this shit, but I think that my goal is to have something. So filings are as much a conversation with the courts as they are a conversation with the public, right? And so filing something pro se, which again is something everybody can do, with the Court of Appeals is a conversation. And it's a conversation to hopefully get the actual information that is owed, but to also draw attention to, based on facts, right? Based on the factual evidence that we have to this point. Here's the hoops that we have gone through. Here is what the actual the courts are saying and what the courts are denying. And that's putting it on the record. And so that is going to hopefully, I don't know, hopefully force, I don't know, whatever. It's going to make me feel better to know that I did what I could do for the cause of transparency, because this is just nuts. Oh God. All right. Well, anyway, so I think that's it. And yeah, I think that whatever. All I can do is try to get the transcripts, I guess, and see if they will refund that money, because it's nuts that the public is being held hostage like that. It's like ransom. So anywho, that's what I'm going to do. So, I am going to then say adieu. What time is it? Oh God. All right. I gotta go. This is just silly. All right. Y'all, smell you turds later, because I hate